Hi, everyone. Welcome. We're going to give it one more minute to see if any additional friends want to join us. Please know that the session is being recorded. However, we will stop the recording at the end of the presentation before the question and answer portion. And look at that. We did get some additional people. Well, welcome again. I'm Natasha Darty, Maryland Public Defender, and I'm happy to have you with us here today to talk about the 2025 legislation, the new laws that were passed, and the new opportunities for reform in our communities. This is being recorded. However, before we get to the question and answer portion, we will stop the recording to allow people to speak freely. So let us begin. All righty. So today's agenda includes conversations telling you a little bit about the Office of the Public Defender, and then we'll jump right into some of the changes in the law that take place later this year. In particular, we're going to talk about expungement. We're going to talk about second look, medical and geriatric parole, as well as restorative justice. And we'll also talk a little bit about how we at the Office of the Public Defender are going to be working to make sure that these laws are implemented and that the greatest impact in positive ways is felt amongst our communities. So we at the Office of the Public Defender find these interactions with community, where we come into the community and have conversations, as an important part of our mission, our vision, and our core values, which centers around justice, fairness, and dignity for all. We are client-centered. We believe in diversity and inclusion. We are a culture of excellence, united in our mission, and we are tenacious advocates. We take our advocacy extremely seriously. We are tenacious not only in the courtrooms, but also in the community. We are tenacious advocates in the Maryland General Assembly, but we also tenacious advocates when we come out to the various neighborhoods, not only to share information that we have, but also to listen. So we are a statewide agency. We have 52 offices that cover from the mountains to the beaches and everywhere in between. Our districts are similar to the districts. We are organized same way as the 12 geographical districts of the District Court of Maryland. As you can see, this is a good representation of how the districts are divided. We are divided in 12 districts, so some of the counties are grouped together. So for example, District 12 is Allegheny and Garrett County. In addition to our trial teams, we have some specialty divisions. These are other important team players that support the work that is done here at the Office of the Public Defender. And there you'll see a list of them that include our appellate work, our decarceration initiative, which will be an integral part of what we're going to be talking about today, the criminal law reforms that have taken place, forensics, forensic mental health, immigration, Innocence Project Clinic. We've had the opportunity to expand on that. Previously, we had a clinic at the University of Baltimore School of Law. On July 1st, we are happy to say that we've opened a second clinic at the University of Maryland Carey Law to expand the work that we are doing. We also have specialty divisions in juvenile protection, complex litigation, mental health, parental defense, post-conviction, social work, and government relations. Another important component of the work that you'll hear about today, as well as the work that we do in the community on a regular basis. So let's first talk about expungement reform and how did we get to where we are today. Well, the work started back in 2016 with the Justice Reinvestment Act, and that's when the Maryland General Assembly consistently extended expungement availability, and they expanded it to misdemeanor convictions. In 2023, the work continued, and they passed what is known as the REDEEM Act. And what was important about the REDEEM Act is that it reduced the waiting period for an expungement by approximately 1/2 the time. So individuals who had offenses that were eligible now did not have as long to wait. And that's incredibly important because we know that expungements are life-changing. They impact a person's ability to gain more suitable employment or housing. It is impactful in that expungement changes lives. We were happy to see with this past General Assembly, the passing of the Expungement Reform Act of 2025. And that continues to address the barriers that we see facing in expungement. And this was specifically for people who had violations of probations from additional, and it expanded to additional misdemeanor charges. So this expungement reform centered around a particular Maryland case known as Abhishek. And that was a 2022 case that held that a violation of probation prevented expungement of an eligible conviction simply because the individual had not satisfactorily completed the sentence. So it was basically one would call a loophole. So after the Abhishek decision, we found that an estimated 43% of individuals who were otherwise eligible for expungement were denied. So the convictions were otherwise eligible, but because of the violation of probation, it prohibited them. Now, when we think about violation of probation, it is a wide range of things. It could have been for missing a simple check-in, a phone call to your probation agent, or missing one meeting during the course of a 5-year period, being terminated from a court-ordered job, or maybe having one positive urine. We were not talking about violations of probation, for example, where someone got a new conviction and was sentenced. We were talking about minor offenses, minor technical violations that were an impediment to individuals who otherwise had done well on their probation from having the opportunity, once that probation was complete, to in fact have it erased from their record. So expungement reform was extremely important, and we saw in Senate Bill 432 an important change. So Senate Bill 432 allows for expungement after the completion of a sentence, even though an individual has a violation of probation. This also allows for the state's attorney or a victim in a case to file an objection and require a hearing. So the state's attorney retains the ability to object if they so fit, and it also retains the ability for the victim to have a say in the outcome of the cases. All other requirements as they existed and the restrictions toward expungement remain the same. The courts have the ability and they continue to exercise their discretion in terms of expungement, but it's most appropriate that the court be given the opportunity to assess the appropriateness of an expungement. And again, this is after the waiting period has expired. The court will consider the person's character. They will consider their probation or parole history. They will consider their overall rehabilitation, and if expungement would be in the best interest of justice. What was also important about the expungement reform is the inclusion of additional offenses. So we see that it includes the ability to expunge driving without a license, stolen credit card, for example, as well as obtaining services by bad checks. These are really significant changes because when you look at these type of offenses, these are the ones that are typically associated with an individual who's experiencing some sort of substance abuse disorder, or quite frankly, offenses that are related to poverty. And these expungements are extremely important because they will open up new opportunities that individuals were previously barred from. We also have to talk about the racial disparities, especially when we're speaking about mass incarceration and we're looking at the timeline of reforms. Now, although expungements largely focus on removing a criminal record for charges that are relatively minor, we must look as to what has historically happened in terms of reform and what its impact. So we saw in 2012 with the Unger decision where convictions were overturned, where the Unger decision, it overturned convictions that had resulted in a life sentence. The Office of the Public Defender, as well as a team of really great private attorneys who rendered their services for pro bono, low bono, helped secure release of 235 people. And those individuals are individuals who had served more than 30 years of their sentence. We are approximately now 8 years later, and I'm really excited to say that the recidivism rate for Unger individuals is only at 3%. We fast forward to 2024, and we see that the Maryland General Assembly passes the Juvenile Restoration Act. That allows for people who have served at least 20 years for a crime that was committed when they were a child under the age of 18 to apply for a sentence reduction. We've also seen an extremely low recidivism rate amongst those who have been released under JUVRA and under Unger, and this demonstrates that releasing individuals who have served long sentences can actually benefit communities. It actually shows the power of the human spirit to change over time and rehabilitate. And it also shows in terms of, as a society, the importance of us welcoming individuals who have essentially paid the time and now have shown that they are no longer a danger to themselves or to others. Oops, I think I see a page. Let's go back. Okay, talked about where we are. So the next big piece of legislation that we saw in 2025, and after much work of Delegate Pastor, previous work by Senator Jill Carter, and the huge coalition of organizations and individuals, was the passage of the Second Look Act. First and foremost, it does not include everyone, but it is a positive step in the right direction. So what does the Second Look Act do? It allows individuals who have been incarcerated for at least 20 years and the offense occurred, and they are individuals whose offense occurred when they were between the ages of 20 to 25. This change in the law helps approximately 500 people. We are currently obtaining information as to who is actually eligible, but at this point, we see that it's approximately 500 who will be eligible for the second look consideration, and that law takes into effect on October the 1st of this year. essentially, after the filing of the motion, the court will consider holding a hearing. And after a hearing, the court may reduce the sentence. However, it does require the court to find that the individual is not a danger to the public and that the interest of justice would be better served by a reduction of the sentence. Second Look Act is an important change in the law, but unfortunately, it also comes with some challenges. And one of the challenges is in terms of how will it be implemented? So the Second Look Act does not provide a right to representation. The Second Look Act does not include funding for counsel. And the other unfortunate challenge is that it takes effect during a time of severe cuts in state funding. However, although OPD continues to operate in a resource deficit, we are working diligently with our partners to determine solutions on how we are going to tackle these implementation challenges. Next, I want to talk about medical and geriatric parole. There was another great step that was taken in the 2025 General Assembly, and it was important because it shows the compassionate release is an important part when we talk about the criminal legal system. Medical and geriatric parole, similar to Second Look, does not encompass everyone, but it does take an important step forward. What it does do is expand the eligibility to those who are over the age of 65 and have served sentences of 20 years or more. It does require a risk assessment if the individual is serving an aggregate sentence of 40 years or more for multiple crimes of violence. What's also important about medical and geriatric parole reform is that it removes the governor from the medical parole process. It improves the standards for medical parolees. And what we found was that chronically debilitated or incapacitated individuals and those suffering from terminal illness, it gives them the better opportunity to be assessed, to be released upon parole. It does medical and geriatric parole, the changes do require extended medical management with healthcare needs. And it also takes into account that these needs would be better met by community services and the individual has been rendered physically incapable of presenting a danger to society or is no longer a danger to public safety. The reality is that our jails and prisons are not equipped to handle individuals with extremely physically incapacitating illnesses. And so we are creating a situation through geriatric and medical parole that we are allowing an opportunity to release those, especially those who do not present a danger to public safety, to be released. And I do make special note that this is not only a change in the law that is to advantage of the incarcerated person, it also speaks to the safety of the individuals who are working within our prisons throughout the state. Individuals who have special medical needs, individuals who are of a certain age, will require a higher level of care and supervision, and much of it is not within the knowledge or aptitude of our correctional staff. They are not medical personnel. So by releasing individuals that are of a certain age, and especially those who do no longer prove a danger to public safety, it is not only saving lives and creating more positive opportunities for the incarcerated, but it also impacts positively on all individuals who work within the prison system. We also look to another important change in the law, and it's more on the front end. An important change to the law speaks about restorative practices in school. This essentially requires Maryland State Department of Education to create a comprehensive plan for restorative schools. That includes a training framework. This includes training for restorative justice practice, so children have a better chance of receiving services, but also understanding their mistakes and the consequences of their actions. Restorative practices, we know, it's been proven, build stronger connections between students and educators, and it does help to address underlying issues such as trauma. And these issues disproportionately affect Black children, and we know this is due to historic systemic issues that occur in schools, in communities, but also it helps to address ongoing social inequities. What's important about the restorative justice practices plan is that it's going to help to foster an environment where students feel heard, respected, and valued. It creates a more safe environment, a more equitable school environment. And this is more in terms of the prevention, dealing with the issues of mental health and trauma, and redirecting behavior in positive ways is extremely important and will help redirect students, children, and we hopefully will lessen the prison population. In our efforts at the Office of the Public Defender, we are fortunate to have important partners. And one of these partners is APDM, Association for the Public Defender of Maryland. They work with the Office of the Public Defender. It is a nonprofit foundation that works with the Office of the Public Defender to help support the work that we do. And in these efforts, especially the ones that we spoke about today, in particular, our second look challenges, the Association for Public Defender of Maryland, APDM, is going to be working with us to create opportunities to expand representation so that we can better assist those individuals who are eligible for a second look coming October 1st of this year. APDM works really strongly, and their belief is deeply rooted in terms of building community and professional partnerships. By advancing the work of the Maryland Office of the Public Defender, they're ensuring the longevity of our mission and values, and ensuring that, in fact, that we are able to continue to serve the community through legislation, education, and advocacy. In terms of our internal teams, I do highlight one of our specialty divisions, decarceration initiative, that will be taking the lead, especially when we talk about our work in second look, our work in geriatric and medical parole. Our decarceration initiative, our team members in that important division, as well as our team members in post-conviction, take the lead in terms of our work when we talk about Unger, when we talk about Druvra, and now as we look into seeking the release of individuals under second look, and assisting individuals with their ability to be released on geriatric and medical parole. Our team members in the decarceration initiative, as well as our post-conviction teams, are really integral in that. They work every day to reduce mass incarceration, and it does take coordination, representation, and support for the individuals who are eligible for sentence reconsideration. APDM is also an important partner when it comes to the work of the decarceration initiative. I also want to highlight expungements, in that it helps to, we talk about the importance of expungements. We talk about the importance of second look, and essentially it's talking about the importance of second chances. And when we give individuals second chances, we're improving their access to housing, employment, professional licensure, as well as making sure that they are able to assess their basic needs. When we talk about giving individuals second chances, we are helping to reduce systemic barriers that exist from racial disparities in the criminal legal system. When we talk about giving individuals second chances through expungements, through second look, and through geriatric and medical parole, we are essentially working to break the cycle of poverty and marginalization. So that was pretty much just an oversight of some of the criminal law reforms that are going to be taking place October 1st of this year. We're going to talk more in depth this afternoon. We will be in person live in Prince George's County at the Real Power AME Church. And we're going to be speaking in terms of how did these laws create new opportunities to strengthen communities. We will be at the church at 6 p.m. this evening, alongside with some community partners, to educate on the new laws, but also to hear from the community how we can work together and how we can better amplify their voices, especially when we are in the courtroom, but also when we're advocating in Annapolis. Our series, In Defense of Us, it is about community. It is about discussing and brainstorming solutions that impact the individuals, impact families, and thus impact communities. On August 19th, we will be in Washington County. On September 16th, we will be in Montgomery County. We continue our events through November. Our October date is October the 21st. And our November date is November the 18th. The October and November locations to be determined. But as you can see, we are going to various locations in the state. If you are not able to be there, please continue to follow us on social media for other events and other opportunities to engage with the Maryland Office of the Public Defender. We are on Instagram, Facebook, Twitter. Our website is listed there. Many opportunities to connect with us. We want to hear from the community as to what is most important to you, how it is that we can better help amplify the voices, and how we can essentially empower you to do the things that are needed to uplift your respective communities. I'm Natasha Darty, Public Defender. That is my contact information. Elizabeth Hilliard, our Director of Government Relations, is listed there. Her contact information, as well as Hannibal Kemmerer, our Chief of Staff. I encourage you to reach out to any one of us or all three of us. Any questions that you may have about this topic or any topics that fall within the criminal law realm. We are the experts, especially when we talk about criminal legal issues. We want to hear from you. We want to engage with you. And thank you for joining me this afternoon. We're going to turn off the recording right now.